Welcome back to Court TV's Open Court. I'm Fred Graham. While other children were studying history or solving math problems at Largo Middle School, Louis Mevic and Sean Caroline and their friends were raiding the refrigerator and playing video games as they played hooky from school. But that innocent truancy turned into tragedy when Louis Mevic took out his father's Magnum .357 handgun and accidentally shot and killed his friend. Mevic pleaded guilty to manslaughter and served time in a juvenile facility, but prosecutors also blame Mevic's father, Louis Sr., for the deadly shooting, and they've charged him with culpable negligence for leaving a loaded firearm within easy reach of a minor. So at this point, we'll return to the courtroom as Prosecutor William Lowry finishes up his opening statement to the jury.
Mr. Mevic is called at work. He comes back. They videotape him. You'll see that videotape, the statements he makes. Many of the stuff I've told you about the history of where he came from and the owning a gun safe and the trigger guards and that kind of stuff will come from his own mouth. He'll also even tell you that the night before this incident happened, he had pulled the gun out, the .357, from under the couch to check it because there'd been a lot of wet weather and he was concerned that it might be rusting. And he looked at it the night before, it was fully loaded, he put it back under the couch that these children all had access to. As I said, the facts will not be in dispute. The facts will prove the defendant left a loaded firearm within the reach or easy access of a minor, that being his son, who's under the age of 16. The facts will prove to you that Louis Mevic Jr., 14 years old, obtained the firearm and used it to cause the death of Sean Caroline. And the facts will prove that this incident was the result of the defendant, Louis Mevic's culpable negligence. Now, this won't be a very long trial, as I said. You'll hear from a number of witnesses, but we should finish it up tomorrow, I would suggest. At the end of the trial, the state will be asking you to hold the defendant responsible for what he did and find him guilty of culpable negligence. The judge will read you the law later on. You will see exactly the elements we have to prove for this testimony and evidence. Thank you very much.
Striking difference between so many of the opening statements that you hear from a prosecutor. No pointing of the finger at this allegedly guilty person sitting there at counsel table with counsel. No passion, no indignation. Well, it's because the situation is that here's a person who, as we've heard before, is not a bad person, but perhaps was culpably stupid, culpably negligent. And the question is, would this even be a crime under other circumstances? And to help us analyze that, we have as our guest Dino Lombardi, who is a criminal defense lawyer here in the New York area, was a prosecutor in Brooklyn. And would you have brought, as a prosecutor in Brooklyn, would this be a felony?
It would arguably be a felony. It would be a tough charging decision in New York because you don't have the statute as on point as the Florida statute about storing or caring for a gun. You would arguably be able to bring a reckless endangerment prosecution against. Would
you do it though?
I think nowadays the case would be brought. I think there are just too many statistics of guns being used in this manner in the home because they're not properly stored.
You know, I want to read the statute because it had recently been passed before this death occurred. This is the first prosecution under it. And the thing that's striking is the Florida legislature could almost have had this very incident in mind when they, of course it hadn't happened yet. But here's what this new law says. It says whoever commits a culpable negligence by storing or leaving a loaded firearm within the reach or easy access of a minor commits, if the minor obtains the firearm and uses it to inflict injury or death upon himself or herself or any other person, a felony. It seems to me that in this case, that's a slam dunk. I mean, that's exactly what happened here.
Well, I would agree with you that the facts and circumstances of the case fit squarely within the statute as it's written. I think the issue factually is going to be, and this will be a tough row to hoe for the defense, is whether or not it was, quote, within the reach or easy access of a minor. Very hard to say that it was not within easy access when it was under the couch. The defense is going to have to argue there was a recent burglary or something like that. Their real, I think, approach will be to say that this was not culpable negligence as it's defined under Florida law, which requires a reckless disregard for human life. That it may have been negligence, but that it didn't rise to that standard.
You know, there's an irony here. The Florida legislature has not passed a law requiring trigger guards.
Exactly.
New York has.
Correct.
So when this defendant, when Mr. Mevic lived in New York, he had a trigger guard. He obeyed the law.
Right.
When he came to Florida, they didn't have a law like that. He didn't take his trigger guard with him. The Florida legislature could have prevented this. Rather than having this guy sitting in the dock now.
That's a very fair point, Fred, because I think even as you noted about the prosecution's tone in this case, Mr. Mevic, and you know, the audience sees him sitting there. I mean, this is just a sad
former fireman,
former fireman, paramedic,
yeah,
a law-abiding guy,
raising his kids,
raising
single
two
dad,
kids, sleeping on the couch.
Yeah.
And so I think arguably this is a guy who, if he was aware that there were trigger lock laws in Florida, would have complied with them. It was not in violation of the law in Florida in the way he stored the gun, but arguably in the way it was used because he had not stored it in such a way. So that's an interesting point that the defense is going to have to try and shoehorn into this case somehow.
I'm not sure it's a legal defense, but we'll probably hear about it. Well, that concludes the prosecutor's opening statement. Coming up next, the defense lays out its case such as it is. But before we get to that, we're going to get the day's news from Amanda Grove in the Court TV News Center.
Ladies and gentlemen, what you will hear in this trial is that after 23 years at the Syracuse Fire Department, Louis Mevic retired. He retired in 2001. He had purchased the firearm in New York, and he will tell you originally it was for sport, but ultimately, because of his duty as a firefighter, he actually carried it with him occasionally. In New York, firefighters are required by law to render assistance, whether you're on or off duty. And so he felt that he needed that there were places, especially in the places where the fire houses were in Syracuse, that he felt more secure in taking a firearm. He moved down to Florida in September of 2001. It would be after the 9/11 incident. And he was the custodial parent since Martin and Louis Jr. were 3 and 5. He has been the custodial parent of the 2 boys by agreement with his wife. When he moved down in September of 2001, she moved back into the home to take care of the boys because he wanted to get established. His brother lived here. He was going to get him a place to live, and he thought that Louis Jr. should finish grammar school, grade school up in New York before he came down. He came down in September of 2001. He ultimately ended up renting an apartment at Whispering Palms Apartment. In the meantime, Sheila Mevic, who is the mother of the boys, started having some problems. Louis Jr., for the first time, had some truancy issues. Started skipping school in New York after his dad moved down here. Louis Mevic will tell you that never occurred when he was the custodial parent. They had a very precise system. You came home, you did your homework, we checked it, and there were no problems in skipping school. He was very adamant about that. So in the March, he finds out about the truancy problems in about March of 2002. Louis moves down after that school year ends, and he enrolls Louis Jr. in Largo Middle School. For the year 2002-2003, Louis Jr. had 5 absences, all of which his father was aware of, all of which were approved by his father. They were usually as a result of them traveling back to New York to visit family or friends.